Sir, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Let's proceed.
Mr. Aldana, can you please state your name for the record?
It's George Anthony Aldana.
And I understand when we spoke, you were in the process of moving. Can you let the court know your current address?
It's going to
Okay,
be
wait. Before you do this, we're on Zoom right now. So, I mean, we're on YouTube right now. Do you need his address to be publicized for the prove up? If so, I'll turn off the YouTube.
No, Your Honor. If you don't need it, I don't need to.
Yeah, you may want to share that with the coordinator. For some reason she needs it, but
Okay.
I just any type of private information that's going to be shared, just let me know and I'll turn off the YouTube.
Got it.
Okay.
And Mr. Aldana, are you Christian Aldana's biological father?
Yes, I am.
And is he currently 14 years old?
If you're going to use the minor's name, we probably should turn off the YouTube, but usually people use initials.
I'll just use CA, Your Honor.
Okay.
And did CA live with you and with his mother?
Yes, he does.
And you understand that he had some medical bills, but only balances existing are on Methodist Richardson Medical Center, Red Rock Diagnostic, and a medical lien?
Yes.
And is it your understanding that the Methodist Richardson bill will be resolved for $41.36?
Yes.
And the Red Rock Diagnostic bill will be reduced to $2,500 from $5,275?
Yes.
And is it true that CA received treatment as a result of the wreck, but he has now been released from treatment?
That's correct.
And is it correct that he had some accommodations at school that lasted for about a month due to his injuries resulting from the wreck?
Yes, he did.
And is it true that CA at this point has no future medical needs related to the wreck?
Correct.
You understand that I am the guardian ad litem who represents CA in this case,
Yes, ma'am.
and you're here to inform the court that as CA's biological father, you've reached a settlement with the defendants for the crash arising on October 30, 2020.
Correct.
And you understand there are 3 payments being issued by 3 different insurance companies for the total settlement in this matter.
Yes.
And the first one is from Infinity County Mutual Insurance. That's the at-fault driver who is paying $9,832.17 towards the settlement.
Yes.
And then each of the underinsured motorist policies, both CA's grandfather and his mother's policy, are each paying $3,500 towards the settlement.
Correct.
Are you asking the court to approve a net of $7,537.54 out of the total settlement to be paid for for CA's bodily injury claim?
Yes, I am.
And are you also requesting that that money be paid into an annuity so that CA ultimately receives $7,807.24 in a lump sum when he reaches the age of majority?
Yes, I am.
Do you understand that rather than entering into a settlement, you could have a jury trial on the case?
Yes, I do.
And that trial, you could get more damages, less, or no money at all.
Yes, I do.
And has plaintiff's counsel, as well as myself, fully explained the settlement documents to you?
Yes, I have.
Do you feel like you understand the settlement agreement in this case?
Yes, I do.
And do you make the settlement voluntarily and of your own free will as to the terms of the settlement agreement and release?
Yes, I do.
And do you understand that the court would not approve this settlement if you had issues with it?
Correct.
Are you asking that the court approve the settlement agreement?
Yes, I do.
Okay. I will pass the witness.
Any other examination?
I have no further questions, Your Honor.
I just have 2 or 3, Your Honor, if that's okay.
No problem.
Mr. Aldana, my name is Kevin Carey, and I represent the defendants in this case for their insurance company, Infinity County Mutual. Do you understand that?
Yes, sir.
And do you understand that if this court approves this settlement, that this matter will then be over forever as it relates to yourself and CA arising from the motor vehicle accident in question.
Yes, sir.
And another way to state that is, even though we don't expect it, if anything were to come up in the future and was somehow tied back to the accident, there is no way to seek any additional sums of money from either the defendants or the defendant's insurance carrier once this matter is approved by the judge. Do you understand that?
Yes, sir.
Understanding all that, you still want this case to be settled? Is that right?
Yes, sir.
I appreciate your time, sir. That's all I have.
Yes, thank you.
Thank you.
So I had a quick question, and then I'd love to hear a report from the guardian ad litem. So it looked like there was a settlement with multiple different insurance carriers to come to this total amount. Did they not have counsel here, or did they want to be I'm just trying to figure out how usually you would have an attorney for each of the insurance companies, but is that what's kind of the story with that?
Sure, Your Honor, and we typically do have everyone present and a different attorney present for everyone. The way this ended up being paid out is all of the money going to the minor and to the annuity is coming from one of those payments, not from the three sources. And so that was kind of the rationale, was the other two are taking care of attorney's fees, case expenses, things like that. And it's really the one infinity payment that is funding fully the annuity.
Mr. Carey, is that okay with you?
Your Honor, as long as I have a judgment signed by you and a release signed by the plaintiff, I'm totally fine with it.
Are you, I guess my main concern is, and because I just want to be fair to everyone, is are you going to be paying the full cost of the guardian ad litem, Mr. Carey? And have you talked to her about that?
We have, I don't know if we've talked about who's paying what percentage, but yes, I am paying the full cost. And I believe we've agreed to $1,500, if I'm not mistaken.
That's what's in the order. And are you okay with that, Mr. Carey? I don't want you to feel like you're being
I
taken
appreciate
advantage
that.
of or whatever. You're the one who showed up, so you have to pay. It doesn't seem fair, but I just want to make sure you're okay with it.
It's totally fine. I'm not that sensitive, but I appreciate the effort.
All right. Okay, good. All right. Mr. Aldana, do you have any questions for me?
No, at this point, Your Honor.
How's your child doing now?
He's doing a lot better. We've been able to get back into the rhythm of exercising, which is kind of a big stress reliever for him. So it's been great to get him back to where he was.
Good. All right. Do you have any questions for me at all?
No, not this time, Your Honor.
Ms. Hernandez, do you have a report you'd like to give?
Yes, Your Honor, and I did file the report of the guardian ad litem on Thursday, so that should be in your file. But I've investigated the case, met with the family, worked about a total of 10 hours on the case, and we were able to find a company, the CMC Benefit Solutions, that does annuities for sums less than 10,000. So that's kind of a rare find.
Yeah, you don't see that much anymore.
Right. But I was glad they were able to do it and, grow the money tax-free at an interest rate of 5.15%. So that's the recommendation at this point, since the minor has gotten better. And just so the court is fully aware, usually I push for the parents of the minor to absorb the expenses if they were involved in the wreck. However, his parents were not involved in the wreck. He was the passenger of a grandparent who was very severely injured.
Mm-hmm.
So knowing that, there's kind of this reluctance to shift those expenses to someone who was very seriously more injured in the car wreck than he was. And the expenses were managed and kept down in the case as well. So I do recommend this settlement and that it be put into an annuity, and have spoken with Mr. Aldana about the fact that CA can come and get that money once he reaches the age of majority.
All right, the court will approve the settlement. Mr. Aldana, I would just say that to make sure that you keep the annuity company informed about your son's address when he turns 18, that sometimes that can go a little, or whenever he's supposed to get the money, but when he turns 18, just so that they know where to send the check. If you move or whatever, just make sure you think about that. But the court, other than that, the court will approve the settlement as requested. You guys, thank you, Ms. Hernandez, for your service today. We appreciate it, and you guys have a great rest of your week. Okay.
Thank you, Your Honor.
Thank
Thank
you,
you,
Your Honor.
Judge. Appreciate your time.
No problem. You guys have a great day. Okay. I think our next hearing is, let me back there here, is Laverne versus Rodriguez. Are both sides here on that?
Yes, Judge.
Yes, Your Honor.
All right, let's go on the record on DC. Tony, are you ready?
I'm ready, Judge.
DC 215099, Laverne versus Rodriguez. Counsel, make your appearances.
Mitch Myers for the plaintiffs. MIERS.
Erica Singler for the defendants.
I do want to note that there's two hearings set today, one at 9:30 and one at 3. I don't mind doing them separately, but I also, if you guys want to, we can do them both now, but I don't know if there's different attorneys covering it or whatever, so I'm flexible either way.
We might not need that second one.
Okay,
I'll talk to Ms. Singler afterwards. We just got some responses on Thursday.
okay. All right, so I think it's your motion to exclude, is that right?
Yes, Your Honor.
All right, you may
Can I
proceed.
proceed?
Yeah,
All right, thank you. Your Honor, yes, as you said, the defendants are requesting the exclusion of a late designated expert in this case, specifically Dr. Garzillo, that was designated untimely. The deadline for plaintiffs to designate in this case.
can I, Ms. Singler, I've read the motion, can I ask a question? So
Certainly.
what role does this expert play? He wasn't a treater, is this an accident and injury? Isn't he the guy from accident injury that always testifies? Is that Brazillo?
Your Honor, I believe he's a chiropractor as well as a life care planner, and he's put together future damages of, it looks like, about $550,000 for the plaintiffs.
Ah, okay.
So, Your Honor, generally, the defendants are asking that this expert as well as the report be excluded because we're going to be prejudiced and we're going to suffer unfair surprise by this report and this designation if it's allowed.
Ms. Singler, give me 1 second. Mr. Myers, why was this designated so late?
Your Honor, and forgive me, I just started with the firm and got this case, so I was not on the case at the time, but here I am. I talked with the previous attorney, and at the time there was ongoing settlement negotiations.
Was that Ms. Greco?
Gibbs 80
Oh, okay.
is the one. There were ongoing settlement negotiations. Also, my understanding, one of the plaintiffs is in school, so they did have a hard time getting him with the life care planner at the time because he did not want to get an expert that he didn't need to get, and he thought that they would be settling this case. So that's why it didn't come in until shortly after the holidays, January 7th.
So this case is set for trial in May, on May 23rd. Is that correct?
Yes, Your Honor.
Okay. All right, go ahead.
So the plaintiffs filed an untimely response to our motion to exclude. We'd ask that it not be considered, but if it is, I want to make a couple points.
Ms. Spingler, is the chronology that Mr. Myers gave, is it pretty accurate or is that not accurate? Was this kind of a settlement? The case was trying to be settled, and I don't know if you were on the case when that was all taking place.
So there was a mediation, Your Honor, that took place on October 4th of 2022. And there was, my understanding, I did not appear at the mediation, but my understanding is there was a mediator's proposal that ran on October 19th of 2022. So plaintiffs still had about a month before their deadline to designate in November of 2022, after they would have been aware that the case wasn't going to settle.
Okay. Did you have anything else you wanted to say, Ms. Singler?
I do. There doesn't seem to be any assertion in the plaintiff's response that, well, there is an assertion that in the plaintiff's response, the defendants wouldn't be surprised or unfairly prejudiced by this. We certainly would be. Our deadline to designate an expert had already run by the time the plaintiffs designated this report and designation for Dr. Garzillo. Additionally, we've been working for, this case was filed in April of 2021. we've been working for that period of time towards this trial, and of course, adjusting our trial strategy based on the timely expert designations that the plaintiff had made by November 18th of 2022. So we wouldn't have the opportunity to designate any additional expert in order to review and potentially refute these significant life care plans. And we don't think that it simply seems as if the plaintiffs are saying, well, it's fine. We put together this ASO and we agreed to it, but it's fine because the court can allow a continuance to give the defendants additional time. And while the court certainly does have the discretion to do that, it's the plaintiff's asking for what seemingly is an equitable remedy for a situation caused by the plaintiffs. And so we would request that this case proceed to trial, that this expert be excluded, and that the plaintiffs not be able to argue that, you know, hey, judge, this order really didn't matter to us. We should still be able to do the same thing that we would have been able to do in the event that we had timely designated.
Okay, response?
Your Honor, to deny an expert would be a drastic measure, and the courts do say you need to show good cause or that there would be no prejudice to the other side. This designation was 136 days before trial. In that, here we are 72 days later discussing it. In that time, there's been no move for deposition of this witness, no move for any kind of additional discovery to flush out any of his opinions or anything of that nature, any contact of whether, you know, we'd be opposed to them getting a response to him. They've had ample opportunity and will still have ample opportunity for this witness. The default rules without a deadline is 90 days. So that shows anything, you know, that 90 or would kind of be the minimum. So here at 136, it's kind of hard to say that you would be prejudiced by this. Personally, you know, I would like to, in the alternative, I wouldn't mind a continuance and discuss this with opposing counsel to kind of reset the table on this and get new deadlines if they need some. I just got some discovery on Thursday. I would like to hire and look at some additional experts based on the things that I just got on Thursday. Almost, you know, 11 months. You know, they talk about getting ready for trial since April of 2021. Here it is, you know, March 2023, and I just got some discovery that we'd requested long ago. You know, to me, that'd be my preferred avenue, is to again just reset the table and get a date a little down the road. But but all in all, they're not being prejudiced by this. They've had over 4 months, 4 months and 16 days.
Ms. Singler, I mean, what I typically do, I'm not saying this is all the time because it's very, very case by case, but in situations like this, what I usually will do is continue the case, let the defendant have an opportunity to have additional time to designate experts, reset both sides, because it sounds like Mr. Myers may need some additional experts as well. Reset the discovery, the expert deadlines, so that both. I don't want to. I understand why you may need your own life care plan or some other type of expert to rebut this life care plan. So I want to give you the opportunity to do that. Have you guys talked at all about the possibility of resetting this for trial?
Mr. Myers
I
did
have an emergency came up and I'm not going to be able to get on this 10 o'clock call with Debbie. Can you see if they have any availability a little
Mr.
later
Desky,
today?
you're okay. Sorry. Mr. Desky was, I don't think realized he wasn't muted. Sorry about that, Mr. Myers and Ms. Singler. Have you guys had a chance to chat about this, about the possibility of moving the trial and resetting the expert designations deadlines?
Mr. Myers did contact me about it. And at that time, I really wanted Your Honor to hear the motion. I will say that in the event the court does elect to continue the hearing, or I'm sorry, the trial of this matter, I would ask that it be continued to maybe like October or November, and I would ask that the defendants be given additional time to designate their own expert, additional time to basically reopen expert discovery and designate their own expert.
I think that's perfectly fair, Ms. Singler and Mr. Myers. That may be a little longer than you want, but I think she should have time to be able to get experts, find experts, get experts, and rebut whatever you designate. So what are your thoughts about that, Mr. Myers?
I would ask that both sides be able to designate future experts.
Yeah, we need a deadline for the plaintiff and the defendant. So,
Agree.
but what I would suggest we do one of two things. One, I put you guys into a breakout room, and then you guys can talk about new deadlines. Let me give you some dates in October and November that would work. Or you guys could just do this on your own and come back at 3 and let me know. What do
Your
y'all?
call, Erica.
I think we could probably do it on our own and come back at 3. Does that work for you, Mitch?
Yeah, that works.
It'll be the same Zoom link. Then we give you some dates, October 3rd, October 10th, October 17th, October 24th. October 31st is particularly good. We only have 3 cases set at the moment. And then November 14th. I'd prefer not to do November 7th because it's a non-jury day, but if you guys really wanted November 7th. Is that enough days for you guys?
That's sufficient for me.
Yes, Your Honor.
Okay, guys, we'll see you back at 3 and see if you guys can work everything out. If you have an agreed order, I doubt you will, but if you have an agreed order before then, and you just want to send it in and cancel the hearing, you're welcome to do that as well. But please let us know so we're not just hanging out on the Zoom.
Yes, sir.
Certainly.
All right, you guys have a great rest of your day, okay?
You too. Thank you.
Thank you.
Thank you, guys. Okay. I think the Desky case is the next one up.
Morning, Your Honor.
Good morning.
Good morning.
Good morning. Let's go on the record, Tony, on DC 227719. Deseki, is that how you say it, or Desky? Deseki?
Yeah.
I think it's Your Honor.
Deseki versus Deseki. Counsel, make your appearances.
Your Honor, Mark Johansson and Steve Smith on behalf of the petitioner, Kim Dasky.
And Spencer Page on behalf of respondent Michael Dasky.
Okay, I've read the briefing, and I guess this kind of arises out of and is arguably related to a divorce proceeding. Is that correct?
Your Honor,
That's correct, Your Honor.
we think, yes, the parties were divorced in 2012. We think we're properly before the court as we've been before. So we're ready to proceed and explain why we think our motion should be granted and there shouldn't be a motion for continuance or a motion to transfer.
Your Honor, may I respond to that?
Let me just say one thing, that the motion to transfer is not set for today, so I'm not going to hear it, but I would urge you guys to look at, I think it's called Fisher v. Fisher out of the Dallas Court of Appeals. It's very similar to this case, with a case involving a married couple that got divorced or getting, I think they're divorced at this point, and they're fighting over the assets of their company. It's a case out of my court that went up on appeal, and very similar to this, the family court judge transferred the case, my case involving the company, to family court, and the Court of Appeals reversed her. I thought she was right, but the Court of Appeals reversed her and said they only handle cases involving the family code, and this should properly be in my court. And so I don't know if that's dispositive. I don't know if it's exactly the same as what we have here, but it does seem very, very similar. So you may want to look at that case before you.
Thank you, Your Honor. We also cited the Underhill case for the same proposition, and also a case, Underhill is 614 Southwest 2nd 178. We also cited the Adwan case out of Dallas, 538 Southwest 2nd 192, that stands for the exact same proposition. So we think for multiple reasons and based on the current case authority, including the Fisher case, we're properly in the right court. May I?
And Your Honor, can I briefly respond, since Mr. Jansen had a chance to respond to that real quick?
Sure.
So the Fisher case, actually, our firm worked at the trial court level on the Fisher case. I think that it is distinguishable here because that involves some third parties, business entities coming in and intervening in the case. So I think that's separate here. Here, we've just got the two original parties. The 202 suit that we're here with today is investigating, I mean, on their own allegations, is investigating potential claims they may or may not have arising out of that divorce decree. So whether or not they think that the 202 should be transferred, it's undoubtable that any action that would come afterwards would be transferable to the 330th. I think the cases that Mr. Johansson just mentioned, I've looked through them myself. None of them cite to the Dallas County local rules. I think they stand for the proposition that you can file a breach of contract or a civil claim independently of an enforcement action under the family code. I don't disagree with that. I think the case law would support that, but we're not here asking for a transfer based on the Texas rules of procedure or the family code or anything of the sort. We're asking for a transfer under the local rules that say that any related case should be transferred to the court of origination, which here would be the 330th. I think the reason that I also think that the court could hear today, because since it's a local rule of the court can sua sponte transfer it. We're fine moving forward on the merits day on the motion to compel itself, but I think that their motion to compel arises out of a very egregious interpretation of the divorce decree. Judge Plumlee in 330, I think she sees that she's going to know exactly what she does or does not need to get in discovery to show if they've got a claim or not. And I think that the initial stuff that they were asking for was, that fine with us. We agreed to, we gave stuff over to them. The stuff they're asking for right now is not covered under their request. It's not in the scope of discovery, and it can't even potentially lead to a claim that they'd have under the family code or under the divorce decree itself. So that's why we think that it may be in the interest of judicial economy. It may be better for Judge Plumlee to hear the motion to compel, because then she can decide what she thinks she'll need in any subsequent enforcement or breach of contract case.
Your Honor, may I respond?
Sure.
So as a threshold matter, the case is not transferable because even if it was a related case, which it is not, it's very distinguishable. It's not seeking to enforce the divorce decree. But even if it was, Mr. Daskey was required to sign a certification of a related case in the first responsive pleading. He did not do so. Instead of doing so, they consented to jurisdiction in your court. They signed an agreed order granting the 202 petition. In addition, they sought affirmative relief and filed a motion for entry of a confidentiality order, which they also signed. So by signing the original defensive pleading, they have indicated conclusively that there is not a related case, and they have consented.
So before we get into a big fight about the transfer, it's not even my decision on whether or not it should be transferred. It's Judge Plumlee's. So Mr. Page, if you want to, I'm not going to usurp Judge Plumlee's authority here. She has the older case. It's her decision of whether or not it should be transferred. I would urge you guys to look at the Fisher case. It may or may not be distinguishable. I don't know. I'm not sure, but I don't want. I'm not going to do a sua sponte transfer and usurp Judge Plumlee's authority here under the local rules. So let's just hear this, and then if you guys want to have Judge Plumlee take a look at this, it's her decision whether or not it should be transferred. It's not mine. So
very good, Your Honor. And by the way, I might add that in 2012 it was a different judge. It wasn't Judge Plumlee. So if it somehow got to her court, she would be starting from scratch as opposed to you, who's dealt with this case before. So on to the motion to compel. Steve Smith, my colleague, going to make that argument, Your Honor.
all right, let's proceed.
Thank you, Judge. So this case arises out of investigation of potential claims, just by way of brief background, related to the sale of a company that was owned by Mr. Daskey, and Ms. Daskey had an interest in that as well. And there are concerns that the money that was received by Mr. Daskey on Ms. Daskey's behalf as well was not fully disclosed when the company Liquid Motors sold in about July of 2021. So we brought this suit seeking to understand and uncover the full scope of this sale. We noted in the 202 petition that the claims include potentially breach of fiduciary duty, fraud, stock fraud, and things of that nature. And the court entered an agreed order granting the request to take Mr. Daskey's deposition and also ordered that we could serve document requests on Mr. Daskey. We did that. Mr. Daskey produced some documents in response, and then we took Mr. Daskey's deposition in November of 2022. And during that deposition, it became clear that he had not produced all of the documents that are in his possession, custody, and control and are responsive to the request for production. So we are asking the court to compel supplemental production, and the specific documents, it's on page 4 of our motion, but they include his employment agreement with American Auto, the buyer of Liquid Motors and/or Liquid Motors. Mr. Daskey testified that he works for American Auto and/or Liquid Motors following the sale, and that his employment agreement was a condition of the sale. In the response that Mr. Daskey filed yesterday morning, I believe they call his employment agreement a bargaining tool or a negotiation tool concerning the sale. And that is responsive to our request for production number 4, which seeks, among other things, any benefits he received in connection with the sale. By acknowledging that this employment agreement was a condition of the sale, we think that means that his employment agreement is obviously encompassed in that request. And I also note that our request for production number 3 asked for all documents concerning the negotiation of the terms of the sale. So to the extent that Mr. Daskey now acknowledges that this was a negotiation point, that's something that should have been produced at the time. And so we're asking the court to compel production of that.
All right, response, Mr. Page.
Thank you, Your Honor. So just as a point of context, and I think Mr. Smith touched on this, but the original company that we're talking about that Mr. Daskey was an employee of and had an ownership interest at the time of divorce was Liquid Motors. The sale was to American Auto. So when we're hearing those two terms, American Auto is going to be the subsequent business Mr. Daskey, yes, he's working for right now. He had no ownership in at the time of the divorce, no ownership interest. It would have been community property subject to division of the divorce decree. What they're looking for right now in this first request is an employment agreement between him and American Auto, who he works with right now, because they think that there's been some underhanded, under the table deal where he's getting benefits from American Auto arising out of them being able to purchase Liquid Motors in the first place. They took his deposition for over 2 hours back in November. They got every document that he has that's related to the sale of Liquid Motors. Not only is there no evidence that there had been any underhanded deal that would make his employment with American Auto subject to the divorce decree, but he testified explicitly multiple times that his employment with American Auto is not related to the sale. He's working for them because that maximized the amount of the payout that American Auto would pay for Liquid Motors, which in turn maximized the payout that Mr. Daskey and Mrs. Daskey got for their interest that's divided in the divorce decree. If Mr. Daskey had said, hey, I'm not going to work for American Auto going forward, American Auto would have paid a much lower price for Liquid Motors because they wouldn't have somebody on board who knows the employees, who has client relationships, the whole 9 yards. If anything, his employment with American Auto is an obligation more than it is a benefit. What they're trying to do right now is essentially say that, well, if he's working for them and that was
guys, we only have 15 minutes here. I'm so sorry. So I'm going to go ahead and grant that motion, grant that request, and the employment agreement needs to be turned over. How many requests do you have? This is only scheduled for 15 minutes.
Judge, we have, I think it's 6 or 7 total, but I can group them into categories to kind of speed this along.
Let's do it quick.
Sure. The next category is documents concerning Mr. Daskey's interest in American Auto that he received. He testified during his deposition that he received 500,000 profit share units in American Auto.
Granted.
And that, Judge, would include, just for the record, documents concerning the value of those profit share units and documents concerning his ownership in American Auto as a result.
Granted.
And then the last category, Judge, is documents concerning payments and other benefits that Mr. Daskey received. We've limited the request to documents post-April 2021, which appears to be about when the sale was contemplated. And Mr. Daskey testified that he has received numerous payments from Don Daskey, who is his father, but also was the largest shareholder, both directly and through his company, in Liquid Motors before the sale. And we have reason to believe that Mr. Daskey received a substantial bonus under the table, so to speak, outside the scope of the documents we've seen officially in connection with the sale from his father or his companies. And so we're asking for bank records showing any payments he received from Liquid Motors, American Auto, or Don Daskey and his entities since April 2021.
Well, hey, anything from American Autos is granted. I'm not so sure about the other two. So Mr. Page, just respond to those two.
Thank you. I appreciate it, Your Honor. I don't think they're payments from Liquid Motors. I think that the allegation would be that they're from American Auto, so I'm not sure why they're asking for those. To the extent they're asking from Don Daskey, who's Mr. Daskey's father, Mr. Daskey testified extensively. He's gotten gifts from his father for, Christmas presents, birthday presents, and then estate planning purposes, transferring money early out of the estate to get it to Mr. Daskey. There's no reason that should be subject to disclosure in this suit. He's got a right to privacy. And Don Daskey himself has a right to privacy in some of these transfers.
I agree with Mr. Page on this, unless if the money was directly from the dad to the son, I agree. If the money was from the dad to the company and then to the son, then I disagree. So any payments made by the dad to the son would be separate property, and that would not be discoverable, or Judge Plumlee can make that determination. If it's a payment from the dad to the company, either company, then that is going to be discoverable.
And Judge, if I could, part of this request also was a request for payments from Don Daskey's company, the Walden Group, which was the single largest shareholder of American Auto. And so we are asking for payments from that entity to Michael Daskey as well.
I believe there was testimony that there were no payments from the Walden Group to.
If there was any payments by the Walden Group to Mr. That would be discoverable if there are any.
Okay, and then can I ask for a point of clarification too, because I'm not sure if Mr. Smith mentioned it, but he also is asking for 401k plan statements from American Auto, which I think are well outside of the scope of what a court could grant, because any benefits he's getting from American Auto and his 401k plan are clearly separate property. I think that goes beyond the scope of discovery. And I don't think there's even any questions or testimony about that being a benefit that would be applicable to his wife under a divorce decree of 10 years ago.
And Judge, if I could respond to that, the testimony during the deposition is that this 401k plan that he received from the new employer was part of his employment agreement, which again, Mr. Daskey acknowledges was a condition of the sale. So this is directly a benefit that he received in connection with the sale by Mr. Daskey's own admission. And I think we're entitled to discover all of those benefits that he received in connection with that sale.
Your Honor, can I respond to that?
So this is what I would say. If it's a situation, I'm going to allow you to discover if the company is making contributions into his 401k, then that's going to be discoverable. If he's made the decision himself to make, he makes $200,000 a year and he's donating, he's putting $10,000 a year into his 401k. That's his decision. That's not discoverable. So any company contributions is discoverable. Okay. Anything else, guys?
Your Honor, just to clarify, at the very beginning of this last category, you said payments from American Auto to Mr. Daskey were discoverable. Just want to clarify that.
Yes.
Okay, very good.
I think are you talking about the 401k or?
Just all payments. It was the very first item Mr. Smith touched upon in this last category.
Yeah, I think that's going to be discoverable, but
very good.
The main thing that's not discoverable will be any payments from the dad to the son, and then any individual contributions that the Mr. Daskey or Daskey, sorry, or whatever, how do you say it, Mr. Daskey, any payments he made into his 401k. That's everything else is discoverable except for those two things.
Very good. Thank you, Your Honor.
All right, Mr. Smith, if you could prepare an order for me. It'll need to say that this was heard on March 20th, 2023. Instead of on this day, you need to share that with Mr. Page, and I need this order before Friday.
Understood, Judge. We'll upload that today.
Thank you, but make sure you share it with Mr. Page first.
Understood. Thank you, Judge.
Thank you so much. You have a
Thank you,
great
Judge.
rest of your day.
Thank you.
You too.
All right. It's a busy morning. Let's go to our next hearing. Anyone here on Villarreal versus Coaster Line Coaster Club?
Yes, Your Honor. Robert Greening, I'm the guardian ad litem.
Tyler Stewart on behalf of defendant B&B.
Stephanie Utah, counsel for the remaining defendants.
And Glenn Tucker on behalf of Nancy Cardenas as the natural mother of Isaiah Leon and on behalf of Rebecca Villarreal.
Are we ready to prove this up?
Your Honor, may I tell you sort of the status of where we are on this?
Sure.
Your Honor, we're ready to prove this up. We have Ms. Cardenas, who is the next friend here, as you see on the video, ready to give testimony.
Good.
The only thing that's outstanding is there were a lot of issues outstanding. We've figured them all out except for one this morning, and that is some indemnification language that we think we have an agreement on in the CSA, but Mr. Stewart needs to run our agreement by his client to make sure that his client's okay with it before we sign off on the CSA. Therefore, what I would propose that we do is go ahead and have the prove up, with your permission, and go ahead and hear testimony. We just can't get a judgment or a CSA to you until we can get this indemnification issue approved by his client and everything gets signed off. I don't know which way you'd rather go. If you'd rather just reset this, Mr. Stewart thinks he can get this approval within the next 48 hours or so, hopefully. So I don't know what to tell you or what to do. I just wanted you to know what the status is.
Mr. Stewart, tell me what's going on.
I have just got to get client approval for these changes that have been made, that were made this morning. And just, I couldn't get it between the conference call that we had at 9:15 where the changes were agreed on by the council and this hearing. So I've just got to send the drafts on to my client for review with my recommendations and get that approval before I can sign off on everything.
Will it take you 48 hours, do you think, to do this?
Oh, sorry, Judge. I think I can get the answers today. I'm pretty sure they're in the office, but I just can't say for certain right now.
I mean, we have a couple options as I see it. One, we could go ahead and just go forward with this, and then you guys can give me an order, or if you're more comfortable, Mr. Stewart, we could reschedule this to this afternoon, and then maybe at 3, and then you guys could come back at 3, and then Mr. Stewart could, because is it possible that this could derail the entire settlement with this indemnification? I don't know anything about it, so is it possible it would derail the entire settlement?
I don't believe so, Your Honor. I believe that I could probably get approval by 3 today. I would jump off this call and immediately start pursuing my clients, just get the approval.
Does that work for everyone else's schedule? Miss Utah, does that work for you?
That works for me, Your Honor.
Mr. Tucker?
That does work for me.
Mr. Greening?
Yes, sir.
Mr. Stewart? Of
course, sir.
And Ms. Cardenas, does that work for you? Okay.
Yes, that works.
All right, why don't we do this then? Why don't you guys come back at 3 and come back either way, even if it's not worked out, so that we can, I think we probably want to try to, my main concern is if Mr. Stewart comes back and just says, no way, I don't want to do this, or we can't do this, or it's going to derail everything. I just hate to get the prove up done and have that happen if that's a possibility. So I will see you guys back at 3 o'clock on the same link. Okay.
Okay. Thank you.
Thank you, Judge. We'll see you at 3 today.
Okay. Bye-bye.
Bye. Rhonda, if you could change that hearing. Are both sides here on the Hammond v. Williams case?
Jeff Seeberger, I'm here for the movement.
And I'm Olawale Israel. I'm here on behalf of Miss Christina Deremi, who's the attorney for Kevin Castillo.
Is that everyone that needs to be here?
No, I believe the plaintiff's attorney was opposed to this motion, and I don't see them.
Is that Mr. Truelove?
Yes.
He's signing on right now.
Okay.
It's not time yet anyway, so it's not, I'm not trying to rush anyone.
And John, I just wanted you to know that Miss Adiremi was called to trial in that court, so I'm just stepping in for this hearing.
Okay. Mr. Truelove, you need to turn on your video. Your case is up.
All right, just wanted to make sure.
Okay, give me 1 second. All right, Tony, you ready?
Yes, Judge.
Let's go on the record on DC 22-13971, Hammond v. Williams. Counsel, make your appearances.
Andy Trulove for the plaintiff.
Jeff Seeberger for defendants Christopher Williams and ATG 16 Trucking.
Israel on behalf of Kevin Castillo.
All right, let's proceed.
Your Honor, I represent, as I indicated, Christopher Williams and ATG 16 Trucking. This is an automobile accident case. We have filed a motion for bifurcation under section 72.052 of the Texas Civil Practice and Remedies Code because it's a commercial trucking accident in which the plaintiffs seek to hold a company responsible for the negligence of its driver. This accident happened in June 16, 2022 in Dallas. The plaintiff was involved in an accident. Defendant Kevin Castillo was changing lanes. He changed lanes in front of my client, Christopher Williams, and the accident that led to a chain of events that caused the accident. At the time of the accident, Christopher Williams was driving a commercial vehicle for ATG 16 Trucking LLC. We have filed a stipulation to that effect, stipulating that Christopher Williams was in the course and scope of employment with ATG 16 Trucking. So pursuant to section 72.052 of the Texas Civil Practice and Remedies Code, we're seeking a bifurcation of this matter in order that any negligence or evidence of negligence of the company be held back for a second phase of the trial should it be necessary, should the employee be found to be negligent in the first phase of the trial.
Okay, that's the bifurcated trial section 72.052.
Yes, Your Honor.
Okay, response.
Plaintiff has no objections to bifurcation. They have a right to do it under the law.
Okay, I thought you guys were opposed. All right, does the other defendant have any opposition, I guess?
No, we had no opposition. I thought the plaintiff was opposed to the motion.
Yeah, I let the other side know that I was not opposed. The initial language said sever, so I thought it was severing the parties. But I emailed opposing counsel a few weeks ago and said that we were no longer opposed.
And Your Honor, when I did file this, I conferred with all parties to the lawsuit, and Kevin Castillo's lawyer told me that they were opposed as well. So I thought we had opposition. Obviously we don't, so we did not intentionally take up the court's time on this for an unopposed.
No, I'm not trying to fuss with anyone. I just, can I make sure, can you guys see this order? You probably can't. Let me try to share it again. Can you see the order? Let me try again. Let me see. So you had said there was 2 different orders. Is this the correct order?
I think that's the only order that we submitted, Your Honor, and that does not call for a severance of the action like plaintiff's counsel was concerned about. So,
okay. Is this the correct order, Mr. Truelove?
Yes, it is.
Okay. All right. I will go ahead and send this to the clerks and all right. Anything else today, guys?
Nope.
Nothing further for me. Thank you, Your Honor.
I've not actually had one of these go to trial yet, and it's pretty new law, so so I'll be curious to see how this all plays out. So it'll be interesting. But you guys have a great rest of your day, and we just sent the order to the clerks. They should hopefully get it uploaded pretty soon. Okay.
Thank you, Your Honor.
Thank you.
All
guys.
righty.
Thank
Have a good
you.
day.
All right. Bye bye.
Thank you, Your Honor. Bye.
Let me just look real quick. Our next hearing is at 10:45.